Welcome to Better Your Business Express, brought to you through University Center partnership between innovation centers at Dixie State University and Southern Utah University. Better Your Business Express is a partnership offering no-cost traveling workshops to Southern Utah business owners to help the region recover and adapt to a post-pandemic economy for the next 2 years. Participants gain exclusive access to regional experts sharing knowledge, skills, and strategies for adapting to ongoing economic growth and change. This training, including audio and attachments, are being recorded for educational purposes and will be shared offline after the meeting. Please be sure to take advantage of the chat box if you have any questions. Please keep your audio muted unless asking a question or making a comment. In today's workshop, you'll learn how to protect your organization and yourself by knowing your legal obligations and rights as a small business owner in Southern Utah. We're excited to hear from Lorianne Barneson, our benefits manager here at SUU. Lorianne, we'll turn things over to you now. We'd love for you to introduce yourself briefly and get started in this wonderful topic.
Wonderful topic. So what I would really love is if the participants would take a minute and just type into chat what you hope to get out of this. Like, what are you here for? I've got a whole deck of slides that's probably way more information than you need about any one topic, but what did you come for? Are you here for OSHA? Do you want to know more about unemployment? You're worried about how to get workers back to work off of unemployment? So we can hit those topics as we go through. But my history, I've been in human resources management for 25 years. I've worked in trucking, hospitality, manufacturing, and construction. Now I'm in the public sector in higher education. I have done all aspects of human resources, and then I had a consulting business for a while where I went around to small companies and helped them set up their handbooks and help them get their disciplinary action forms in place. And so I have a lot of knowledge. If you've got any specific questions, just dump it into chat and we'll gather up that information. But I'm excited to hear what you're here for so that we can touch on those things specifically. I think I can open the chat. Okay, all right. And then Colette and Susie, if you just want to help me monitor that as we go through.
Yeah, you bet. I'll be happy to do that.
Okay, great. And I'm just going to get started. I talk quickly, and so don't be afraid to unmute your thing and just go, hey, Lori, I have a question. Because I get rolling on content. So just go with me and let's get started. All right, so we're going to do employment law in 60 minutes. It's impossible, but we're going to get through most of it. When in doubt, get a professional. So what you need to know mostly is sometimes you're going to need a lawyer, right? Who needs a lawyer? Everyone. If you find yourself in a situation where you've got some questions, it's always okay to ask a lawyer. Your useful internet sites, write these down or I'll share this presentation with Susie and she can get it to you. But you're going to need to know these sites. If you choose to be an employer in the United States and in Southern Utah, you're going to need these sites. So keep those in mind. And then I would suggest you can go to the Utah Labor Commission and sign up for their frequent emails. So if anything changes, the Labor Commission will send you an email that says, hey, there's an update on this law, or did you know, or those kinds of things. So I'm signed up at this website so that I just get the periodic updates. It's a great idea to go and get yourself signed up for. All right, so here's everything in my deck today. So if you have something that you want to like pause on and really deep dive into, or if you've got something else that's not on here, let me know, but we'll try to touch at least briefly on all of these topics. If you're an employee in Utah and in the United States, all of these are going to affect you somehow, and we'll talk about how. All right, who's covered by what? FMLA is for 50 employees or more. If you're an employer and you don't have 50 employees in a 75-mile radius, you don't have to use FMLA. It's best practice to be familiar with what that is, and it's best practice to honor the terms and the conditions of FMLA, even if you're not required to by law. And we'll talk about what that is. It doesn't cost you any money. Really, it's just a tracking system to keep track of how many days people are away from work. OSHA is for everyone with one employee. So it doesn't touch you folks that are self-employed, but if you have even one employee, OSHA is all yours. Minimum wage is one employee. And then the new FFCRA, that's Families First Coronavirus Response Act. That's for everyone with less than 500 employees. Let's see, I didn't know who was coming from what states, but both Arizona and Utah are at-will states. At-will just means that your employer has the right to terminate you at any time for any reason without giving you any notice. And the employee has the right to quit at any time for any reason without giving any notice. The exceptions to that is if you have a written contract in place, then the employee would have to give you a certain amount of notice, like perhaps they were a salesperson or something. And the handbook does not constitute contractual employment. So if you have an employee that you terminate and they say, oh, I have a wrongful termination lawsuit because I had a contract, because it says in the handbook that I'll go through the write-up process. The handbook doesn't constitute a contract, but we are at will. The exceptions to this are discrimination, retaliation, and refusal to do an illegal act. If you want somebody to swing from your rafters and they say no, you can't terminate them for not violating an OSHA regulation. But at will just means you don't really have to go through the write-up process, although that is a best practice. The National Labor Relations Board, this is an entity that came into place back when those workers like in New York and Chicago were forced to work long hours in horrible conditions. The employees finally band together and did a bunch of strikes, and they formed the NLRB. And even if you're not a union shop, even if your employment doesn't ever touch union work, you're still bound by some of the union regulations. For example, if you allow anyone to advertise in your workspace, you have to allow a union organization to advertise in your workspace. So lots of companies with a lot of employees, you have those billboards up and anybody can put a billboard up. But if you allow Subway to stick a coupon up there, if someone from the Labor Relations Board comes in and says, hey, we're looking for truck driver union supporters and we want to advertise in your shop, you have to let them advertise in your shop if you've let anyone else advertise in your shop. The other thing that the NLRB report that protects even for non-union workers is your employees have the right to talk about their work conditions in any circumstance. So they can get together and complain about what a horrible boss you are, and that's not against the law. They can put on Facebook what a horrible boss you are, and that's not against the law. As long as they're not disparaging you based on race, creed, color, religion, or harassing you, making you feel unsafe at work, they can get together and talk about the work conditions. And it is just a way that they can band together to create a better work environment for themselves. Where this also comes into play is you cannot have a policy in your handbook that says your employees are not allowed to discuss their wages with one another. Lots of handbooks that I've seen still say you're not allowed to talk about your wages, and that violates NLRB. So you have to take that out of your handbook if it's in there, but they are allowed to get together and discuss whatever they feel like would improve their work conditions or their pay. Even if you're not a union shop, those are your union shop laws. Fair Labor Standards Act. If you are a employer in Utah, if you're in the public sector, so anybody that's a Utah state employer wouldn't necessarily have to follow these rules, but if you are exempt from this law, that means you have to have a policy in place that tells us what the law is. But if you're a private employer, you're in it. You're in Fair Labor Standards Act, which is what governs, we'll go to this one, child labor law, youth and minors. Does anybody want me to dumpster dive into the youth labor? Do we need to, does anybody want to know what youth workers are allowed to do in these types of employment? Just really quickly, 12 and 13 can babysit and mow yards. 14, 15, 16, 17 can work at retail shops, like retail food places and retail shops. 18 and older are just adults. All right. Fair Labor Standards also does overtime. The thing about overtime is this. In Utah, it is a 40 hours in a designated work week. So somewhere in your employee handbook, you have to have it declared, this is our work week. Most people go Sunday, 12 a.m. to Saturday, 11:59 p.m., right? They just do the calendar week, but you can set that week on whatever week that you want it to be on. But once you declare that week, if your employee works any hours over 40 hours, they have to be given an hour and a half of pay for that time. It's 1.5 times. And then Utah has a minimum wage law of $7.25. Other states have greater minimum wage. So if you're operating and you have dual employment in multiple states, you want to make sure when they're performing the work in the state, you pay them the minimum wage of that state. So if they cross the border into Arizona, minimum wage over there, I think, is $12 an hour. You want to make sure that they're getting the minimum wage in the state where the work is performed. Doesn't matter where they're paying taxes. Let's see. And then if you've got employees that you want to call exempt, so there's people who are eligible for overtime, which now seem to be the elite, right? So before it was more preferential to be exempt, right? Because then you didn't have to report your time, right? And sometimes in the past, exempt employees could work a couple hours and go home because they got all their job done. Now everybody works more than 40 hours. It would be nice to be eligible for overtime. But so what happened was employers came around and they said, hey, you're exempt, which means you don't get overtime. But then they gave the workers so much work to do that they couldn't possibly complete all their work in a 40-hour work week, but they weren't paying overtime. So the federal government came in and they said, hey, we're going to make it so that you can't take a minimum wage employee and not pay them overtime. They put a floor in there of $684 a week. So if you're not paying your employees at least $684 a week, they're eligible for overtime. Then also, there's a duties test. So the employee has to perform certain duties to be eligible to not get overtime. So I've got them listed there: executive, administrative, and professional. Most of us would fall into an administrative exempt, meaning non-manual work, right? Like this is where you want to put most of your office people. But what you have to remember about these people is that they have to make decisions of a significant importance. Can they make an autonomous decision that's worth $5,000 or more to your company? If your person that you call exempt because you want them to work more than 40 hours without paying them overtime, if they needed to spend $5,000 on a purchase and they had to call you and get permission, they don't have autonomous work duties, right? You have to make sure that you're really qualifying them properly. The other thing is that they can supervise 2 or more people and then still be exempt. So if you've got people that you just want to pay, it's easier on payroll. If you just pay the regular amount all the time, you don't have to worry about overtime. Make sure that they meet these duties tests. And the problems with this is that the employee knows if they're not getting their just desserts, right? So if you have an employee that you say, hey, you're exempt and you're not getting overtime, and they end up working 50 hours a week. I was helping a customer one time, and we were working on job descriptions. And the lady at the front desk was typing her job descriptions, and she had everything that she does at work. And then she had duties that she does after work. And so this particular person was a non-exempt employee. She was due overtime, but her boss felt like he paid her enough in other ways that he didn't have to pay her more than 40 hours. So he was treating her as an exempt employee, but she had her list of things that she does on the clock and her list of things that she does off the clock. Employees know, and it's sort of like your ex-boyfriend or your ex-girlfriend. At some point, they're gonna hate your guts, right? So always treat your employees as if at some point, if you do something wrong and they feel like they're treated unfairly, they may throw, like, you put pebbles in their pockets, right? You tell them a little bit of a dirty joke here. You don't pay them for their overtime there. You're just putting pebbles in their pockets. Eventually, if an employee becomes disgruntled, they're going to throw all those things back at you. And not paying a person for work performed is one of the things that will get you in trouble the fastest. So penalties, what your employees know is if you're not paying them their overtime, or if you're allowing them to perform work unpaid for, like you allow them to take phone calls at home and you don't make them log those and pay them for those, you're violating the FLSA. The penalty for that is the amount of the unpaid wages and overtime. Liquidated damages is twice that, plus their attorney fees and the cost of all of the lawyer's fees. And what the courts assume you know on every single law that we're going to talk about is the employers are presumed to know the law, and they believe that you either knew your employee was doing it or you should have known your employee was doing it. So as an employer, you have to know the law. And then if you violate the law, the judges will say, you're the boss of your company. You should know what's going on in your company. So you either knew you were violating the law or you should have known you were violating the law. And if they determined that you actually did know and you were complicit, like the lady that said, here's all my duties and then this is what I do after hours, her boss knew that she had after hours work performing, they would have found that to be willful violation. And it's a 2-year statute of limitations. So if you have an employee that's gone from you for 2 years, and then they realize that you violated this law, they can come back 2 years after they're not even your employee and ask for those back wages. Okay, Family Medical Leave Act. This is that one that we were talking about. You have to have 50 employees or more, but it's a good idea to understand this law because if you violate the privilege of this law, somebody can still say you're discriminating. And it'll fall into other things, right? So what this law does is it protects employees that have to be away from work for 12 weeks, up to 12 weeks, which is 480 hours. It protects their job and it protects their insurance. So they can come back to the exact same or very similar job and job circumstances, and they have the right to have their benefits continue during this time. If you're a very small company and you can't honor FMLA, you should honor it as far as you can. You don't have to go 12 weeks, but I would suggest at least as long as you can. But I would memorialize that in writing and say, hey, you're not eligible for FMLA, but here's what we can do. Maybe for 3 weeks, we can cover your job for you or something like that. But if you are an FMLA employer, you need to know how they qualify. That's your employee has to work for you for a full year, and it's a rolling year. So look back 12 months. And then during that look back of 12 months, they have to work 1,250 hours, which is part-time. 2080 is part-time, right? I mean, 2080 is full-time. So you're going to look back a year, and you're going to look back and make sure they worked 1,250 hours. If those two things are true, and you're an employer with over 50 employees, then you have to guarantee this job protection. It is not paid. It's just a tracking system for time away from work. What qualifies this medical condition is it's for them or their spouse or their parent, unlike other insurances, or their children. And any of those people would have to have a serious health condition. A serious health condition is a period of incapacity and treatment of 3 consecutive full calendar days. You can remember this as the Friday, Monday Leave Act, right? If somebody misses a Monday and they said they were sick all weekend, they could potentially qualify for FMLA because that's 3 consecutive days of incapacity, right? It doesn't have to be 3 work days. Then they have to have treatment 2 or more times within 30 days, which means I go to the doctor and he says, yes, you're sick, come back in 2 weeks for follow-up. That qualifies. And then they have to have a continuing regimen of treatment, which is a prescription, right? So you've got a person that misses 3 days of work, including Saturday and Sunday. They're sick for 3 days. They saw a doctor, they have a follow-up appointment, and they get a prescription. They could potentially qualify for FMLA. Then you just commence the tracking system is all it is. So you don't have to pay them when they're using FMLA. It's a parallel tracking system. They can use paid time off for that time if they want to continue pay. Some employers have it in their FMLA policy that their employees are only allowed to use half of their paid time off while they're on FMLA. It literally reduces their pay by half while they're away from work for a medical condition. That's legal, but it kind of motivates the employee to get back to work, right? It's a good way to get it back to work. But just keep that in mind. If you're under 50 employees, you'll want to make sure that you have some kind of consideration for medical leave. And you want to do the same thing for everyone, right? Like, we don't want to give so-and-so's dad time off for his heart surgery and then not give so-and-so time off to have their baby. Like, because employees know what you've given other employees. You want to make sure you're consistent. Rather you're bound by FMLA or not, you want to make sure you're consistent. What's not covered is over-the-counter medications, and pregnancy is not a FMLA qualifying event. Just the fact that they're pregnant is not enough to be FMLA. They have to have some kind of complication, or the surgical hospital event of having the baby qualifies for FMLA. If you violate FMLA, there's lost back pay and lost front pay and liquidated damages, which is double. So the judge would look back at what the employee lost for their time off. He'll look forward at what they would have made once you didn't allow them to return to work, and then they double that for the penalty. Does anybody have any questions so far? We're good? Okay. HIPPA. So HIPPA is a law for everyone. That it's exactly like the doctor's office, right? You go to the doctor's office and they have you sign the thing that says they promise not to call your employer and tell them that you have a bad back, right? You want to make sure, you personally want to make sure that your doctor doesn't talk to your employer and tell them something that you want to manage on your own, right? Or your ex-husband can't call your doctor and say, tell me what my wife's got going on, right? HIPAA is to protect your medical information from people who you didn't authorize to know your medical information. But HIPAA on the employer side is also things like, I can't be in the lunchroom and say, oh my gosh, Susie came in today and enrolled her new husband in insurance. Yay, I found out she's married, right? The HIPAA violation there isn't that Susie got married. The HIPAA violation is that Susie enrolled her husband in insurance, right? We can't casually comment about anything medically related to anyone and their family. So I can't, as an employer, put together a fundraiser for somebody who has to have surgery. That's against the law. You can have a coworker do that. If a coworker wants to, if the employee shares that with a coworker and says, hey, I have to have this surgery and it's going to be really hard, your coworkers can put together a fundraiser for you, but you, the employer, cannot initiate that fundraiser, and you should not. So even if you're in just a passive supervisory role, pass that off to a lateral employee. That would violate their HIPAA rights. And it sounds funny, but I have literally sat in disciplinary action meetings where a really well-meaning supervisor who was in the ward, the religious ward of someone, asked the employees to do a fundraiser, and they did. Then the wife of the supervisor went around and gathered the money and got it all together. The employee came in and got the money and then filed a HIPAA complaint, because the supervisor should not have told his coworkers that they had a medical reason. Even though he appreciated the money and received the money and took the benefit from the fundraiser, he still had a valid HIPAA complaint. We should have passed it off to a lateral employee. So no passive comments. If you are in a supervisory role, you can never say, Susie got married and enrolled her husband, or Susie's having a baby. Those things. Sorry, Susie, I just use Susie as a generic person, and then here you are.
Yeah, I have one of those names.
So Susie isn't getting married or having babies. And if you are, I don't know. But I'm like, sorry, Susie. Okay, let's see. Okay, Affordable Care Act. I really was super excited when ACA came around, because it sounded like it was going to do so many great things. It fixed things like we can keep our minor children and our adult children on our insurance until they turn 26. That was a big deal, because that 20-something population was generally uninsured. They were in school, or they didn't have jobs that were good enough to get them insurance. So we had this whole population of people not insured. So that was great that our kids could stay on our insurance. It removed all pre-existing conditions. So back in my young mother days, I knew if I left my employer for any reason while I was pregnant, I was never getting my baby covered and any other employer. I had a pre-existing condition. So people didn't have to worry about that anymore. People with asthma. I have a sister who has a son. I'm violating HIPAA. I have a sister who has a son that had asthma, and their entire family could never be covered on insurance, because no matter where they would go, they would fill out that pre-qualifying condition worksheet and be denied. But so ACA took away pre-existing conditions. If you're a mom and you show up at a job and you become eligible for insurance the day before your baby comes, your baby's covered. You and your baby are covered, which is amazing. It did those kinds of things. It made every single person eligible for some kind of insurance. What it took away was now there is this exhaustive number called no maximum coverage. Before, I could say, I will cover an employee up to $1 million of a condition. My insurance would be $1 million. So when I went to the doctor for my very aggressive cancer, he had to decide, was the medication going to be better or the treatment going to be better? Did he have to keep time in there? Did he have to keep a cushion in there for $1 million in case I needed a lung transplant, right? If I had lung cancer. So the doctors were very, very conservative on their care on the front end. Maybe didn't give you the medicine that would help early on because it looked like you're probably going to need a lung transplant down the road, right? Open that up. So now there's no limits. Sky's the limit. So your doctor can literally give you a prescription that's $100,000 a month, and your insurance has to cover that. And then they can give you treatments that are $500,000 a treatment, and your insurance will cover that. So what happened was our insurance used to have a stop loss at $1 million, and then it stopped covering that condition for a person. Now there's no limit. Doctors can prescribe you very, very expensive prescriptions at the beginning, the very, very, very expensive treatments, and it goes on forever. So our insurance has had to reach clear to infinity with coverage. So now they go, if we have somebody on our plan that has lung cancer, we've got to build in enough money to cover that to infinity dollars. And that's what made all of your premiums were used to in the late 1900s when this was early turn of the century stuff. Your insurance premiums were probably like 160 bucks a month. Now insurance premiums are like 1,400 a month. That's where that big leap came in, is that because there's no limit for any kind of illness, and there can't be a limit. Doctors can prescribe whatever they want. And you've probably seen that when a new commercial comes on, you've got something like rheumatoid arthritis and you're sitting at your couch and there's a commercial that comes on, and there's only 2 countries in the United States that allow pharmaceuticals to advertise directly to the consumer. That's the United States and France. But we get commercials saying, hey, if you have psoriasis, ask your doctor for this medicine. Or if you have rheumatoid arthritis, ask your doctor for this medicine. And you can go to your doctor and your doctor gets a kickback for giving you the medicine. The pharmacy gets a kickback for giving you your prescription. And then the pharmaceutical company has a big buildup for research and development. And your insurance can't care. They just pay that big bill just because you saw it on TV or the doctor said, hey, you seem to be doing okay on this medication, but there's a new thing and I'd like you to try it, right? So that's what we have in our insurance. We've built in all of this room for research and development. It's a great thing in some ways because our medical evolution has gone leaps and bounds, because pharmaceuticals can do the research and development and doctors' offices can try treatments that were which were previously too expensive if you were covered in a group plan. But yeah, it's a great thing and it's a terrible thing all at the same time. Everybody can get coverage, but everybody gets coverage, right? So great thing and a terrible thing. COBRA. So if you offer your employees any kind of coverage and they leave your employment, they have the option to take your coverage with them for 18 months. So like at my employer right now, our cost for our benefit, our most popular plan, is about $1,500 a month. My employer pays 10% of that. So I pay $150 a month. My employer pays the rest. When I leave my company, if I want COBRA, it's the full employer cost plus the employee cost and 2%. So if my employees want to take my insurance with them, they're going to pay $1,500 plus 2%. So if you're an employer with a very rich benefit program and your employees pay very little for their premium, COBRA feels really expensive to them. If you're on a plan where you're only covering the employee, but the employee picks up the full cost for their family, COBRA is not going to feel too bad for them because they're already picking up a lot of the cost for that. But it is the employer cost plus the employee cost plus 2%, and they can have it for 18 months. New fun COVID fact: if you laid off an employee because of COVID and they would have been eligible for COBRA, but they couldn't afford it, right? Like they didn't pick it up because they couldn't afford it. If they're still in that 18-month window past the time that you laid them off, as of April 1st, they can enroll in your COBRA and you, the employer, have to pay that for the time that they would be eligible for the rest of COBRA. There's federal tax reimbursements and all of that stuff. The hard thing about what they did with FFCRA and this reimbursement program is you, the employer, have to front the money and ask for it back. It's still coming out of your pocket up front. So when they were first talking about doing this expanded COBRA for these laid off employees, they were talking about wrapping it all the way back around to April of 2019. But that would have been us employers having to pay 12 months of those premiums and then picking up all of those medical costs that those employees might have incurred, right? So good news, it is only going forward. But if you have an employee that you laid off, your COBRA administrator has probably already reached out to you and said, give us a list of your laid off employees so we can offer them this expanded COBRA. And that will go on for 18 months past their termination date. They'll be eligible for expanded COBRA.
Lori, we have one question before we move on. and this is about your previous topic, how does a doctor get a kickback for prescribing meds? Isn't that unethical? And also, how would the drug company have the info that the doctor and pharmacy prescribed it without violating HIPAA?
So the every company is incentivized, right? Like even your insurance company can get a kickback for having a pharmaceutical. It is just the way it is. So a pharmacy company makes a drug, and then they literally have little pharmacy salesmen with little briefcases going to doctor. You've probably seen him at your doctor's office. And he goes in and he says, here's this drug. If you prescribe it, we'll give you a kickback. And then your pharmacy, of course, has a fill cost on top of what the medication costs, just like any retail person. And then if your PBM, if your pharmacy benefits manager has that contract with the pharmacy and they allow that drug to be on the plan, your benefit company can have a kickback. So the pharmaceutical companies in the American economy, we're all consumers and we're all in this, oh, I wish I could think of the word right now. It's just business economy, right? They can go out and incentivize their customers to get customers, right? It's just big business, and it happens. So what pharmaceuticals do also is if you're an employee that makes less than a certain amount of money, which is usually around $111,000, you could ask your employee to go to that pharmaceutical company and get their discount directly, and then they'll give it to your employee directly rather than running it through all of those people. The middlemen always have uptakes, right? Like the middlemen always have upcharges. So if I got a prescription and it was a very expensive prescription, I could go right to my pharmaceutical manufacturer and say, I'm a lower income employee, I make less than your threshold. I would like the employee discount, and I can buy it straight from them. But it's just the workaround. So you just have to know that it's there and it's available. If you have a medication that's working for you, you don't need to change. I wouldn't recommend changing just because they want to try something new and test it in the marketplace. But HIPAA, doctors can share information between each other. Doctors can share information to your pharmacy. The only thing it prohibits is other people like you. So a doctor can't tell your ex-husband, and the doctor can't tell your mom, and the doctor can't tell your employer. But if the doctor refers you to another doctor, they can share that information to another doctor, and they can share it with your pharmacy. Right now, if you have a scheduled prescription, like if you need a narcotic painkiller, you have to have a medical reason to get that painkiller, and they do share that medical reason with your pharmacy. So your pharmacy can say, it doesn't seem like your shoulder injury is bad enough to need this many narcotics, right? They're allowed to share that between other vendors back and forth to make sure that you're getting proper care. Did that answer the question? It's like commercialism. That's the word I was looking for. It's commercialism. We live in a really great country where everyone's allowed to make a lot of money if you can figure out how to make a lot of money. All right. Okay. COBRA. So myth about COBRA. Most people are like, you have to get your COBRA notice within 7 days of terminating. I don't know where that ever came from, but I can't tell you how many times I have an angry ex-employer storm my office and go, you didn't give me my COBRA notice on time. The law is I, the employer, have 30 days to notify my plan. Then my plan has 14 days to notify the participant. So if I wait right till the 30th day to notify my plan, then the plan waits right to the 14th day to notify the employee. They could literally receive their notice within 44 days of their termination. Best practice, get it out as fast as you can. The employee has 60 days to accept COBRA, which means they can go, like if they leave your work and they go to another work and their other work has a 30-day waiting period before they can enter benefits over there, they can play the COBRA roulette game where they don't pick up your COBRA. They just wait And if nothing happens to them in that 30 days, they get on their new plan and go on, because there's no pre-qualifying paperwork, no pre-existing conditions. So they can just wait. They don't have to elect COBRA for that month. But if they get 3 weeks into that month, something happens, they can loop back and get on your COBRA account for that thing, and then hop on their new one going forward. So they have 60 days after the time of receiving the notice to apply for coverage, but they have to go all the way back to date of termination. So if we play that game where we don't give them the notice for 45 days, then they have 60 days to elect it. They would have to pay premiums all the way back to 3 months to get the coverage 3 months later. So best practice is get your COBRA notices out straight away. The very best practice is, if you offer benefits to somebody, have a COBRA administrator. It'll cost you about $5,800 a year, and that is so not worth it to do it yourself. Just pay the COBRA administrator. They're in charge of the notices. They're in charge of the timelines. All you have to do is tell them when you terminate someone, and they'll take care of the rest. But yeah, make sure that you're getting those notices out so that your employees don't have a huge burden if they come back on your plan later. All right, sorry, terrible slide. Title VII of the Civil Rights Act of 1964. This is when, I loved this time in American history, because when somebody marched for rights, they wanted the rights for everyone. So when Martin Luther King Jr. stood up and said, "I have a dream," he didn't say, "I have a dream only for this group of people." Like when people march now, they only want rights for their little cluster of people. And they're not asking for these new rights for everyone. So now every group has to have an active ongoing rights challenge. But at this time, 1964, it wasn't just race and it wasn't just color. They put the law in for race, creed, color, religion, sex, gender, all of those things. It was encompassed at that time. And it was made so that if I, as a woman, went in to apply for a job and I had 3 men that applied as well, if I was equally qualified for the job, they couldn't eliminate me based on my gender. Or if I was not the predominant religion, I couldn't be eliminated solely based on my religion, my race, my color, my whatever. How this affects small employers is you're going to have people come in and they're going to be doing applications, right? And your little front desk person will be writing on the applications, and they're going to need to describe the person. So when they come out, they'll know who to get from the lobby, right? Train your people that whatever they write down is memorializing something in writing. So if she writes "black lady with the curly hair," right? Then she takes the application back to the search committee, and the person that's in the lobby saw her write that. She's going to have more anxiety knowing that she's walking into a room that have already discriminated against her based on unconscious bias, right? And then if she doesn't get the job, she'll say, "I know they already had a predisposed opinion of me before I came." And so make sure that in this, we use descriptive terms such as "man in the red shirt" or "person with the shoes," whatever. Describe something about their appearance that doesn't have anything to do with their national origin, so that you can keep yourself out of this. I've seen in other things, age is a big thing because we have a very aging workforce, right? With the baby boomers still in the workplace. And so we have age discrimination. Anyone over 40 is potentially an age discrimination case. So doing performance evaluations, I had a supervisor that was really, really wanting to help their worker, and they just wanted him to step down from being machine operator and keep his same pay. But that is the loss of respect and the loss of perceived authority, right? So they're saying, now that you're older and a little slower, we think, and so I went back and I said, can you say, based on your performance, we'd like you know, we'd like to move you back to this position with the same pay. And they went, okay, I'll do that. And then they wrote, as an older worker, like, stop saying older. Like, is it because the man is old, or is it because his performance is lacking? Like, let's talk about what it means to the piece of machinery he's standing in front of. Machinery don't care how old you are. Machinery cares how fast you're working, right? Machinery doesn't care if you're pregnant. Machinery doesn't care if you're a boy or girl, right? So what did it mean to that piece of machinery, what he was doing? And it was because he was slow. And it didn't have anything to do with his age. It was that he was slow. So make sure when you're doing those kinds of things that you don't use descriptive terms that might be interpreted as discriminatory. The exceptions to this are Native American preference. I can, as an employer, say I would prefer to hire a Native American, and then I can hire them without the qualifications, right? I can say veterans preference, then I don't have to care who else comes. If, you know, I don't have to care if a woman comes or an over 40 Asian female comes, I can hire my veteran. If I'm a religious organization and I employ a leader, like if I'm a Baptist church and I want to employ a rabbi priest, I don't even know if that's, I'm sure that's not right. If I'm a Jewish church and I want to employ a rabbi priest, I can say they have to be Jewish because I'm an employer, I'm a religious employer, and I can say that person has to be part of my religious organization. National security, if I'm going to work for the President of the United States, I don't get to say because I'm an over 40 Asian female, I get to have preference. They can hire whoever they want. Seniority or merit-based increases, those can be, those don't have to take into consideration the EEO, the equal opportunity stuff, and percentage of imbalance of EEO. So the EEO, the Equal Opportunity Commission, was created to correct the mistakes of the past, right? So if I have an organization that's completely filled with men truck drivers, right? I can say I can disregard all of you men because I need a woman truck driver. I have to meet my EEO requirement because I'm a federal contractor and they want me to have a certain percentage of female truck drivers. Doesn't matter that you're slightly more qualified, I have to have this woman. So I can say my EEO percentage is low on this person and they can have preference. And that is not discrimination. That's correcting discrimination of the past, right? So even though it feels like discrimination today, right now, in this moment, towards a certain group of people, it isn't. It's just bringing those numbers back in. And then the other thing that Hooters brought us was bona fide occupational qualifications, right? So if I have a qualification, so it's the best reference ever. Hooters was not allowing men to be waitresses because they had certain occupational qualifications. And so there was a lawsuit and the judge actually ruled that says one of their occupational qualifications is you have to have these two certain assets. And if you don't have them, you don't get the job. So there are bona fide occupational qualifications. If you want to be a hair model, you have to have very long hair. If you want to be a hand model, you have to have very pretty hands, right? So there are those things really, really hard to prove. So if you're going to dismiss someone of a certain ethnic group or someone of a certain religion, and you're not a religious group, and you say, oh, I have a bona fide occupational qualification that they have to be a man, and you can't prove it, you don't get it. So it's really hard to prove, but just know that that's out there as well as an exception. Title VII brought about the Me Too movement in 2006. So all of you probably have heard about it. Formed in 2006, this really great lady, Tarana Burke, really did start it as just a personal tribute to her effort, and it got picked up by mainstream media where women tell their stories, but now everybody has a story. So you need to be really, really careful and really, really aware in your workplace. We're all looking for a story. every single one of your employees wants to be part of this Me Too story. So I go and I teach Title VII classes to employers, and I always have somebody walk up to me at the end and go, back in the day, my supervisor touched my butt. What can I do? They hold on to this stuff for a long, long time. Employees remember a time that they were uncomfortable at work. You as an employee probably remember a time that you were uncomfortable at work. So as an employer, you want to train your supervisors to not violate this law, right? On this law, it is any negative employment action, perceived or actual. So if my employee thinks that I wanted them to go to dinner with me, hey, why don't you come have dinner and drinks with me later? And they go, oh no, I really am not, I'm busy. And then tomorrow I don't do their employee evaluation very favorably. They can say that had they gone to dinner with me, I would have given them a more favorable employee evaluation because they perceive the dinner to be maybe more of a social event. It doesn't have to be sexual in nature, but more of a social event. So I would always keep your interactions. If you have a guy and you're a guy, so you're a bunch of guys, right? And you say to the guy, hey, all of us guys are going to go get a beer after work. And this guy says, hey, I don't drink, I'm not coming. And then later, this guy, the non-drinking guy that didn't come for a beer, doesn't get put up for promotion. He can actually say you discriminated against him based on your sexual orientation idea of men should drink beer, right? So, supervisors and subordinates should just not mix company. It's a great rule in the military. It should be a great rule in your business. But anytime an employee has that flinchy feeling like, if I don't go drink beer with these guys, what's that going to do to me later? They're going to remember that when something negative happens to them later. So really, really great business practice. Teach your supervisors to not have any kind of personal connection with your employees. And that's really hard because we spend more time with our coworkers than we spend with our spouses. We spend more time with our coworkers than we spend with our children. How do you not have a personal connection with somebody that you sit next to all day long, right? So be consciously aware that anything that down the road could be perceived as inappropriate or maybe causing the person to be selected or deselected is outside of the bounds of Title VII. It doesn't just have to be, oh, go ahead, Susie.
We just had a question. Is there a statute of limitations on making a complaint regarding the Title VII?
If it's determined to be actual abuse, no. Forever. So that's how, who was that guy, the Steinberg guy or whatever? Like he had people coming back 30 years later, right? Because he had the interview couch. If it's determined to be abusive, there's no limitation. And so you want to make sure your supervisors right now can be defensible, because if your supervisor is making these kind of overtures towards their subordinates, joking or not joking, no matter if you say they joke with everybody, if the employee files the lawsuit against your company, you have to defend it as if that was your company's position. So you, the employer, either knew or should have known it was happening. So if I have a supervisor that says, I am not hiring that person because I don't like that religious belief, and then they don't hire the person, and then the person sues the company, your supervisor speaks on behalf of your company. Unless you can prove that you've trained them every year that your company position is A, B, and C. So your best defense against this is training your supervisors every year. Show that every year your company took a stand. We do not tolerate discrimination. We do not tolerate harassment. We do not tolerate bullying in the workplace. So that when an employee comes back and says, my supervisor did this, my company knew, when you're defending that case, you can say, I can show you the times that supervisor sat in our company training to show that this is inappropriate behavior in our work. Then you have a better a better position to say the supervisor was wrong, but the company isn't wrong. You still have to defend the supervisor, you still have to pay the bills, right? But now your company isn't at a willful violation stance. Like you can say, my company didn't know. But if you can't prove that your supervisor was trained differently, then your supervisor speaks for the trees. He's the Lorax, right? Like whatever he said is what you said. Let's see. Okay, switching to OSHA. OSHA, 1970, people were going to work and they were required to work on roofs and put on roofs on steep slopes. They were not safe at work. Employees banded together and said, we deserve to come to work in a workplace that's safe. And we're talking about all the things. So I, as an office worker, I have to know that my company has a safe work environment and that my conditions of employment are safe. So I won't be asked to hang a picture on the top of my wall by standing on my wheelie chair. I know that as an employee, that my employer will never ask me to stand on the top rung of a ladder to put up a poster, right? Because that's part of OSHA. But whatever companies you all are in, you have different OSHA requirements. And if you're in manufacturing or if you're in construction, those have some really strict OSHA requirements. And the problem with OSHA is, other than serious, $13,000 per violation. And if you think these people are walking in your place to find one thing wrong, you're crazy. So they come in, you have an employee that says, hey, my employer expects me to go to the top rung of the ladder to paint this tall wall every single day. And I've asked for a taller ladder and I don't get a taller ladder. OSHA's coming and they're going to look at your ladders and they're going to look at your ladder inspection. And then they're going to look at your hard hats. And then they're going to look at your other PPE, right? They're there to find a problem. So your best defense against OSHA is don't violate it. Know the law and then follow it. So whatever your work environment is, you need to go research your OSHA requirements and make sure you're following those. And they will nickel and dime you to death when they come to your place. So that is what I have for all of the employment law. The next thing I want to talk about is how can we put this in place for all of our employees? Like we've got some employees that need some kind of consideration and some employees that need other kinds of consideration. And the worst thing that you can say as an employer, that's the way we've always done it, or I don't care, that's the way we do it, right? So when an employee comes to you and they have a safety issue or they have a harassment issue or they have a pay issue, don't just brush them off. This slide here is my favorite slide about equity and fairness. So if you treat every employee, regardless of who they are or what they're doing, exactly the same, you get this little kid standing on the exact same box that can't see the ball game, right? Equity is actually making it so all of their heads are above the fence, right? So you treat every employee as an individual and you're never going to have a problem. But the second you start going, oh, hey, that's just the way we do it, you're going to have a problem. So every single comment or complaint has to be dealt with on an individual basis. Let's see if it's valid. Let's see what we can do. My best favorite line is when somebody comes in and starts talking, say to the person, how can I help you? Because they have an idea of what they want. And then you, the employer, can decide if that's beyond your scope, right? Like I can't turn a full-time job into a part-time job because you need help, right? I can say the essential function of the job is that you have to work every day. And then we can see what that means. Can you work every day if you have a bigger monitor? Can you work every day if you have a better chair? Those kinds of things. But I would always encourage you to make sure that your people have equity in their treatment. Like you get all their heads above the fences. Once their heads are above the fences, then if they still can't perform the job, then you can let them go based on inability to perform the essential work functions. Was there another question, Susie? Something just flashed across my screen. Nope, probably not.
Not a question, just love the visual.
Oh yeah, no, this is my favorite. You can Google kids on boxes equal fairness and you'll get all of these. They're just on the internet, but yeah, this is my favorite. Okay, preference. Let's talk about your unconscious bias for a minute, okay? I'm a dog person. I love dogs. I am not a cat person. I come to work and Susie and her friends are at the water fountain talking about cats. I'm probably gonna go get my drink of water and I'm gonna walk away. But someone else is at the water fountain. Joe and his buddies are at the water fountain and they're talking about dogs. I like dogs. So I'm gonna visit with Joe a little bit longer, right? Because all dogs are nice and all cats are mean, right? Here's a visual that shows you that all dogs are nice and all cats are mean. And so I'm going to the water fountain and I don't like that picture because all dogs are nice. I don't want to look at it anymore. So I go to the water fountain and I talk to Joe and his friends about the dogs, which means I develop a relationship with Joe, right? Me and him, now I see him, I'm like, hey, how's sport? And hey, and he's like, hey, after work, I'm going jogging and I like sport, my dog. And Susie's like, hey, my cat Mittens. And I'm like, yeah, bye. Bye. I don't develop a relationship with Susie in my work because I don't like cats, because my bias is an open bias towards dogs, right? So now Susie and Joe come into my office and they're up for promotion together. Who am I going to promote? I developed a relationship based on a bias that had nothing to do with race, creed, color, religion, gender, right? Because I have a preference for dogs. We talk about dogs and I developed this relationship with my dog people. And I have a dislike for cats. And so I just naturally avoid developing a relationship with somebody who always wants to talk about the cat, right? I guarantee you, if any of you just log on and you do unconscious bias exam and you take the little quiz, you'll find out what your unconscious biases are. And I'm telling you, in North America right now, every single one of us, women included, have a preference, a bias preference for men in leadership positions and tall men and pretty small women, right? That is just our North American bias. Are you a bad person because you perceive men in authority positions? Absolutely not. But what you need to do is you need to recognize the fact that your bias may be influencing your perception. And so when you have a man come in and they say, hey, I would like to be in a supervisory position, your brain goes, yes, you should be in a supervisory position. If a woman come in and she says, I'd like to be in a supervisory position, and you go, let's see your resume, right? Attend to your bias. All you have to do is stop the fact that the bias is there. So if you have a natural inclination to stand at the water cooler and talk about dogs, or to identify with women, or those kinds of things, all you have to do is go, I have the bias. You're not a bad person for having a bias. That's okay. We all have preferences. We all grew up in a certain kind of home, and we all developed survival skills based on certain things and based on certain patterns. That's okay. What's not okay is if you act on your bias, it's discrimination. So if you say, I prefer dogs, so I'm going to promote the dog person, I've now discriminated against the cat person. And when I'm talking about dogs and cats, think about religious, or think about gender, or think about race, right? If I'm only talking to people at the water cooler who are white, because I have a bias against Black people, I'm going to promote the person I know, but I didn't develop a relationship with the Black person, right? So if you exchange my entire example for any other discriminatory practice, right, you're going to get the fact that you are naturally going to be inclined to develop relationships with people that you have a natural preference for. And it's not wrong of you to have the preference, just be very aware of it, attend to it. My least favorite thing, I used to write for a magazine, and every once in a while, somebody that was a part of that magazine would say, I don't see color. And I would be like, that's really sad, because that's a part of their identity. And saying that you don't see that means you don't care. Like see their color and then appreciate it. See their national origin and appreciate it, and then attend to it. I know I'm most familiar in Cedar City, growing up a Cedar City native, I'm most familiar with white Mormons. That doesn't mean I don't see Hindu or Buddhist people. I do see them. I love their culture. I want to know their culture. So the best way to overcome this unconscious bias, first attend to it, and then second, go immerse yourself in the alternate culture. Go sit through church at somebody else's church. Go to lunch with your diversity and inclusion group at your local university. Go learn about those people. The worst thing that you can do is withdraw, because if you withdraw, you're pulling back into your own culture, and then you're literally making choices based on what you think you should be doing, which is almost as equally as wrong as what you shouldn't be doing. But spend some time in those areas with those people, and you'll overcome your unconscious bias, because you'll develop a new conscious bias of preference. That is all I have. This class takes a lot longer to teach in person because people talk.
We do have one question that just came in. When setting up a situation for equity, does that open the door where other employees can ask for more?
Absolutely.
Thinking accommodations or benefits they aren't receiving, how does one ensure an employee's private info isn't made public if the employee is asking for equality and threatening to sue?
Okay, so let's say that we have a person with a vision impairment, right? And it's not a well-known vision impairment, but they're asking for a larger monitor. And everybody wants a big monitor, right? But you're giving your asker the larger monitor as an ADA accommodation, like the doctor says this person can do their job better if they have this larger monitor, right? So all of your employees watch the monitor come sit on the desk, right? And then they're like, hey, I want a larger monitor. And you are allowed to say that was a reasonable accommodation. You don't get to say what it is, but you're allowed to say that was a reasonable accommodation. And then you don't have to give all your employees the larger monitor. But if all of your employees come to you with doctor's notes that say they also need a larger monitor, you're in for it, because, equity is equity. Does that answer the question? You can say that was an accommodation.
Yes, I think so.
Mm-hmm.
Just running back to some of our earlier comments. We have one asking, I'm interested in getting people off unemployment and back to work after COVID. Do you have any suggestions there?
Okay, this is a great exercise. Think about, is this person asking the question, are they a business owner or are they an employee?
I'm not sure.
If the person's here, do you want to unmute your microphone and then we can have a conversation?
That was actually my question.
Okay.
This is Colette. So I asked that question because I work with employers, and I'm working with several who are trying to get employees back. And I know that the governor just today made some changes from the state level to help encourage that, but they're really, really struggling right now to get employees back for the tourism-based businesses in Southern Utah.
Right. Okay. So for those of us that are here in this meeting, I want you to think about what kept you from creating a situation where you could get laid off and go home and make $1,000 a week. Raise your hand if you make less than $1,000 a week. Like, right, we all make less than that. So what did Lori, stay at work for? What conditions of employment made me come to work? And you people that are the business owners or the self-employed people, what made you go into business for yourself? What kind of work environment did you think you could do better for yourself? All of you thought you'd get better hours. None of you got better hours. If you work for yourself, you work all the hours. But if you think about those things, if you start making a list, my list, Lori's list is, I have a job I could not easily replace. So when I came back into the workforce, I wanted a job with similar or same conditions. I can't find that just anywhere. So you as the employer, can you create a work environment that your employee could not easily replace? Guess what? Nobody works for money anymore. We can get money from COVID, and we can get money from unemployment, and we get money from our mom and dad, and we can get money from a billion places, right? Nobody works for money. We come to work for something else. We come to work because our job gives us longevity income. Our job gives us intrinsic value. We feel good about what we're doing. We know we're making a difference. In a manufacturing environment or in a tourism environment, how can we make our employee feel like what they're doing today is making a difference for tomorrow? If they're putting bags in boxes, bags in boxes, bags in boxes, what else can we give them? They're not working for their money. We can make money anywhere. They're not working for their job intrinsic value. What else are you going to give them to make them feel like they should show up every day? It's a job that they can't easily replace. So if I'm an employee in the service industry, I can quit my job in manufacturing. I can quit my job in the service industry and go down the street and find another job tomorrow, right? Every place has now hiring signs. So what makes your place better than the neighbors, right? So you've got to come up with something, and the answer is in your own answers. Why did you stay employed when you could have gone home for more money and been with your kids? What made you continue your employment? Longevity income, intrinsic value, making a difference, right? If I had to ask all of you people here today why you stayed employed, can't replace my job, I get great retirement benefits, I have something beyond today to come to work for, right? Otherwise, I'm going to go home and I'm going to tell my kids. I got kids. I don't want to be home with them. They're teenagers. Some people have kids they like at home, right? And so think about those reasons why you stayed at work, why you stayed employed, why you didn't go home for the money. Because as a mom and a single mom, I know there were days I thought, why do I go to work every day? If I can figure out how to get laid off, I can make more money by being at home. And I went, I have a really great job. I have really great benefits. I have really great, I feel like I make a difference every day at my work, right? So what can I give my employees to make them say those same things? Those will get your employees back in the door, but more importantly, they will keep your employees from leaving your door when your neighbor posts a help wanted sign. And that is a really fun activity for people in person. Anyways, anything else?
Yes. How would you handle a situation where, due to funding, two employees with the same needs are not able to get the same equipment? Is it okay to offer one name brand product and give the other employee a non-name brand, or how would you handle that?
So in the accommodation world, there's this thing called undue hardship. If you, the employer, can prove that there's undue hardship, that so you have a doctor say Susie needs a larger monitor, and a doctor say Colette needs a larger monitor, right? And you can only afford one monitor at a time, right? So you give Susie the larger monitor until your next pay cycle. What can we help Colette do? What can we do to make Colette's situation better? And we ask her doctor for an alternative method. We ask Colette for an alternative method. Hey, your request came in second. We don't have the funding for it right now. What can we do to help you? Employees always have an answer. If their answer is, I need a bigger monitor right now, you would have to prove to a judge that it would cause your company undue hardship to provide another resource that quickly. But you do have the right to say this is going to fall under undue hardship for 3 months. and then we'll find you a workaround for that amount of time. Get you a monitor that sits closer, or, you know, whatever it is. But you explore those possibilities. The term is called the interactive process. And if you, the employer, can prove that you went through the interactive process with your employee, hey, undue hardship, what else? Doctor says this, that's also undue hardship, what else? Doctor says that, maybe we can do this. As long as you can prove the interactive process, you can probably prove undue hardship.
Okay. An over 50 employee working remotely due to COVID, who's having computer issues due to connection with company site. And the supervisor makes the comment that she has 11 workers and you are the only one with issues. You then find that everyone is having a problem with the system. Could this be alluded to age discrimination?
Did she really just say, you're the only one? And did she make any reference or any insinuation that it had to do with their technology smarts, right? So there is an age, I don't know if it's called illness, technology resistance, right? We hit a certain age, every human hits a certain age where we become technology resistant. It doesn't matter what we learned up to that point. We hit a break and we go, I am not learning one more VCR clock. I don't care if it's wrong forever, right? You know, your mom and dad did it, right? Their VCR was always wrong. There's a certain age where you hit technology resistance. If your supervisor implied that they were having technology issues because of their age technology resistance, then perhaps the person would have to prove that it happened, number one. I love this. If you can document it, it happened. If you didn't document it, it didn't happen. So was it a phone call or was it by email? Did you all know that if you push send on a text or an email, that's your intent to legally record? So it used to be when we wrote stuff down, if I had something with a binder, like my notebook has a binder, I don't know if you can see that. I just have this notebook and I write everything in it, but it's a bound notebook. That's my legal intent to record on paper. If it has a binder, if it's a legal pad that you rip out, and if it has perforated sides and you rip it out, that was contemporaneous notes that had no point. That's why lawyers always wrote on legal pads, right? Contemporaneous notes, not admissible in court. But if you're in a workplace and you type it and push send, or you text it and push send, that's your legal intent to record. So all of your texts and emails are admissible in court. So if your supervisor wrote that, the spirit of the email will be considered. And guess what? The judge listens from the perspective of the victim. So it doesn't matter what you said, it matters what they heard, right? So be aware that you always want to memorialize everything in writing in a neutral tone. So in basic,
she said it was a phone call and that she documented it in her log. So would that count as proof?
So if she wrote, I told them they're the only one, that's fine. Were they literally the only one? She just needs to go back into that log and write, after this conversation, I discovered that more people than this person was having the problem. And they're fine. But at that time, the supervisor's experience was they had one employee with a problem. So it's okay to say, I have one employee with a problem. It's not okay to say, my old guy can't figure this internet thing out, right? So as long as it was just that, and as long as once that supervisor discovered that the problem was more global, they go back into that same note and write, this was a problem that was happening to more than just this person, they're fine. But if the person feels like that supervisor is consistently treating them worse than other people, might be a perception issue that maybe the supervisor just needs to speak more generically to that person.
Okay. And then just in general, if you can think of any major changes in HR that that have taken place due to COVID or the pandemic that might be useful to this audience?
So you'll all remember we had to pay sick leave. That's over. Now it's your choice to pay it. And then you had to pay 2/3 of the pay if the kids' school wasn't in session anymore and they had to be out, then they should have got 2/3 of their pay. I think it's making us employers more savvy about keeping an employee longer, right? Like it felt like a relief in the beginning that we could just let these people go. And all of us HR people in the beginning were going, pay the bills, they'll never come back. Like once you turn these people loose, they'll never come back, right? So, but I think it's helping employers be more aware of the work conditions. Maybe not their work rights, their safety and their harassment, that kind of thing, but what else can we give an employee to make them want to stay regardless of the economic future, right? I think it's making us better employers, or we will be better employers when we get our employees back.
Great. I don't see any other questions, but I did want to remind the audience again that we are recording this presentation, and we plan to post this and all of our training at the Southern Utah Business website. So those, they are not available right now, but they will be very soon on that website. Thank you for attending this Better Your Business Express training. Be sure to click on the evaluation form that I'm going to drop into the chat. We will also be emailing that evaluation form out very soon. And we'd love to hear your feedback, what you found useful and what you're looking for as other training topics. Thank you, Lorianne. This was such an important topic, and we appreciate your time in presenting today. We hope that you all have a wonderful day. Thank you.
Thank you for having me.